I want to welcome everyone to the early morning session of the Fourth Circuit this morning. It's good to have you with us, and we got three interesting cases and good lawyers. We look forward to the arguments. In the first case, Cincinnati Insurance Company versus Levi Owens. Mr. Parker, looks like you're up first. Good to have you with us.
Thank you, Your Honor. May it please the court, my name is Jay Parker, and I'm here with my co-counsel, Mr. Jason Luck, and we're honored to be here representing Mr. Levi Owens, who is the personal representative of Christopher McLean, who is his deceased son. I'm not going to go through the facts. I think it's more important actually to give you all an update really quickly on something you can take judicial notice of, which is the state of the underlying state court proceedings and where that is. A big part of our arguments concerning why the federal DJ action should have been stayed by the district court has to do with the nature of the underlying proceedings. The district court found in its order granting summary judgment that there was a valid and enforceable default judgment that had materially prejudiced Cincinnati Insurance Company and prevented them, or precluded them really, from defending the underlying tort claim. Well, now, when the notice of appeal was filed, there was a pending motion to vacate that default judgment. The special referee denied that motion, and since then, Mr. Wayne Hunt, who's the defendant in this appeal, but is not a party to this appeal, and is the defendant in the underlying tort action, he has since appealed that order denying his motion to vacate the default judgment. So what that means—
Now, what state are you in now? North Carolina?
South Carolina, Your Honor.
But you're talking about the South Carolina case.
Yes, Your Honor, it's a North Carolina insurance policy, but the tort action occurred in South Carolina.
I understand, but you're not talking about the federal case.
Okay, I got you.
You're talking about
Your Honor, I'm talking about the state court proceedings for
right.
the default judgment for the tort action.
Yeah.
Sorry about that, Your Honor.
That's where
It's very confusing.
that's where the special master was.
Yes, Your Honor, special referee, we call him in South Carolina. But so right now what we have is we have a default judgment in the tort case regarding the death of the decedent in our case that is there, but it's reversible, okay? It's a valid and enforceable judgment.
So what happens if it's reversed? I mean, the statute of limitations run. I mean, what are you gonna do about that?
If it is reversed in the South Carolina Court of Appeals?
Yes.
Well, there's several different ways that could happen, really, if we're talking about it. Because what we had was in South Carolina State Court, a motion to vacate a default judgment. That can be granted for several reasons. One, it could be a service issue, which there is an underlying service issue in this case. But two, they could find excusable neglect for not defending and answering.
There's just a lot of procedural stuff here. You didn't try this case from the beginning, and I mean, there's a problem with the case, and the problem ought to be resolved in a different way than where we are right now. Who in the world just sues the driver of a vehicle he doesn't even own, it's leased by an employer? It's a truck. I know that personal injury lawyers go after those kind of cases, wrongful death cases for truck type. I mean, who would not go and find out who owns the truck and the insurance policy?
Well, I think there's two very good questions in there, and
I'd like to hear the two very good reasons.
I'll try to. So, the back end of your question, why was this done the way it was? Mr. Luck and I actually were not counsel in this case.
I'm not putting it on you. I know you weren't counsel on it. I'm just saying, what is it? Actually, that was a pretty seasoned personal injury firm. They didn't do little cases from what I recall. I don't figure it out. I can't figure that out unless you figured because he was a permissive driver, then the M90 would cover him or whatever. I don't know.
Well, so this is what we think happened when we look at it. And it's the reason why the MCS 90 endorsement exists, the policy reasons behind that exist in the first place, because the trucking industry was abusing the use of borrowed, leased vehicles to hide from financial responsibility. And so in this case, when we look at the collision report, what does it say? It says Wayne Hunt was the driver, it gives his address, and it lists the owner of the vehicle as Penske Trucking. And so, and I can't answer.
Penske had leased it
Penske had
to
leased, I'm sorry, Your Honor.
Wilmington Trucking Company,
That's correct, Your Honor.
and nobody bothered to check on that.
Again, from what I know from the record, I can't answer that because I wasn't
That's a
counsel.
pretty simple question there. You know Penske is the one that leases. Who wouldn't go and get the lease contract and look at it?
Your Honor, I wasn't counsel of record early
But you're the
on.
only one we have here.
That's
Yeah.
So
right,
you-
Your Honor.
That's not a good explanation. You're the lawyer that's here.
But I think that that's, what we're here for is the motion to stay and the entanglement that comes with the underlying state court case. Right now, we're answering questions that are relevant to the state court proceedings in front of the South
Well,
Carolina
that's
Board of
relevant here
Appeals.
too. I mean, because it all comes down to the fact that you only sued Hunt. You don't have a judgment against WSC, and that's what the whole problem is, that nobody told this insurance company. This has been 10-something years ago, and they didn't know it. They got a $5 million default judgment. So it almost looks like it's strategic. You go get a judgment against a driver for a default judgment of $5 million. You haven't told anybody else whatsoever. Driver obviously doesn't have $5 million. Who in the world would do that? Where do you think you're gonna get the money from? You know, I bet you can't get it for that driver, because if you did, you wouldn't be standing in here now. Is that right? You can't get $5 million from the driver, can you?
No, Your Honor, we are seeking supplemental, we are engaged in supplemental proceedings in
I
state
understand
court
what
right
we're
now.
engaged in,
And-
but I'm getting to the heart of you. You can go in terms of the legal arguments, but the problem with this case is the lawyering in it. And the fact that you only sued Hunt. You can argue all day long in terms of, well, the M90 should do this, or whatever, the case law is against you on that point. You can argue the other points in it, but the bottom line in the case that you are facing now, even procedurally, is that you don't have a judgment against WSC, insurers with them, and when you look at it, give you an oral argument in terms of it, but don't think you won't answer questions regarding how this all came about from the beginning, because there's no such thing as, I'm only gonna talk about the law and I'm not gonna talk about the rest of it.
Well, Your Honor, I think that, and I appreciate that, and I agree with that it is important. It is a question that I wish that I could give answers for how this was filed and why that wasn't done. But that is why we're in the
But you have to
procedural
work with what you have to work with.
stance where I am right now, where I do have to pivot to the law.
Was it, you didn't sue WSC because everybody was in a hurry and the statute was about to run?
I would have to speculate, and
Well, you
I would have to
done-
speculate about
well,
that, Your
I'm
Honor.
assuming you've done some work on the case here. You'd know a little bit.
I'm in a unique position where the attorney who originally had this case, there's absolutely no way I can communicate with him and learn why he did what he did. All I can say is how I've handled it coming into it, and again, which goes to the MCS 90 endorsement, and Your Honor, your words about futility and whether we should have been allowed to amend our answer and add a counterclaim asking for a declaration that there is a suretyship here.
Has there been a legal malpractice action brought in this matter?
I'm not aware of one, Your Honor.
Looks like something ought to be brought. I'm not saying it should be, but
Well,
I
it's,
don't believe you'd file a case looking like this, would you? I just don't think, the reason it becomes important is because we like to have some precedent. But I haven't seen a case where the plaintiff's lawyer just sued a driver and who was not the owner of the vehicle, leased by someone else, insurance companies insuring that person who leased it from Penske, but only the driver, and nobody seems to even look to try to connect or notify anybody else in the case. Is there a case like that?
I've not seen one like that, Your Honor, but I don't know, again, how this did happen with this getting filed.
Regardless of how it happened, I'm saying we're looking for precedent, looking for some guidance. Who has seen a case like this?
I can say that these facts
I have never seen
are truly
one. Have you?
unique. I wish that I could have found, I guarantee you, I look for one. There's nothing that
There's
we
a
can talk
good
about.
reason
that's
for
not-
it, because
Did you
that's
know
not
about
what
the-
you do.
Did they know about the insurance coverage when they brought the lawsuit?
I'm sorry, could you repeat
What
that?
did they know about the insurance coverage when they brought the lawsuit?
The understanding, I believe, when the lawsuit was brought was that coverage was going to come from Penske.
Coverage was gonna come from Penske. That's what they thought that brought the suit.
Again, I'm speculating
Well,
that that's where,
But have you done an investigation about this?
well, our state court proceedings are still ongoing, and we don't, and that's again why
You're trying to bring us up to date on the state court proceedings, and we've interrupted you. You haven't finished that yet.
that's right, because the state court could turn around and say, there is no, they could
What's
vacate.
going on in what state court?
In South Carolina Court of Appeals,
Pardon, the South Carolina Court of Appeals has an appeal of
an appeal by Mr. Wayne Hunt to vacate, to reverse the special
by
referee.
Hunt.
That is correct, Your Honor.
That's the driver.
That's correct, Your Honor.
And, okay.
And it's to vacate,
And he's provided with attorney by Cincinnati Insurance
that's correct, Your Honor.
under a reservation of rights.
That's correct.
So they're taking care of Hunt at this point.
That is correct.
And so they're taking an appeal to the South Carolina Court of Appeals
That's right.
on what kind of an issue?
Whether or not the default judgment should be vacated.
Whether the default judgment should be vacated. And so you're thinking that that has some bearing on the coverage dispute in the federal court?
Yes, Your Honor. It absolutely.
That's why you're telling us this.
That's why I'm trying to. I've been trying to.
Well,
They've been prejudices.
I've been trying to get us back to this. The material, if you look at the district court's order, the material prejudice that the district court used to justify saying no coverage, no defense, is that Cincinnati was unable to defend the underlying tort action. If South Carolina Court of Appeals a year from now says we are vacating that default judgment, the whole basis for the district court's order is now the feet are taken, the card of the House of Cards is taken away, and the House of Cards will fall. And now that turns this into a trust guard issue, where now what the district court has done is it's issued.
Why is it a trust guard issue? There's a final judgment, right? They
Final,
were
but
notified
reversible.
of their obligation to defend, so that's out. And, I mean, there might be a split of authority on duty to indemnify, but everybody agrees that once there's a judgment, there's a duty to indemnify is triggered. And so, I mean, South Carolina law says there's a final judgment when the amount of the money is, entered. When the judgment is entered, we don't have to wait for a motion to vacate and the appeal of a motion to vacate and maybe cert on the denial of appeal to motion to vacate, right? There's a final judgment.
There is a final judgment, Your Honor, but when we're talking about final in that sense, we're meaning final in the sense of appealability.
Where does that come from?
The rules of civil procedure and the.
Well, like where do we say that there's no duty to indemnify, that you can't proceed with this sort of DJ action until all appeals have been exhausted?
That's not, you can receive a declaration that you don't have a duty to defend before all appeals have been exhausted, but that's in cases where you're holding up the four corners of the tort complaint and comparing it to
Or
coverage.
to indemnify. You don't have a duty to pay. You don't have a duty to indemnify. You get that with a final judgment at a minimum.
Sure, but in this case, the duty to defend is directly tied into the default judgment, because if you carefully read the district court's order, it doesn't say some other reason for saying you don't have a duty to defend. It's all tied into being materially prejudiced by a default judgment. The thing is that if the South Carolina Court of Appeals vacates that default judgment, the whole premise of the district court's reasoning is now gone, because the district court said there is a default judgment that has prejudiced Cincinnati. If there is a reason why the South Carolina Court of Appeals vacates the default judgment, but service is still good, there is an ongoing South Carolina case.
The question is whether the duty is triggered and then whether they're prejudiced. I mean, you're trying to put it all on prejudice.
Well, the duty was triggered when they received notice of the lawsuit. But then the question is, can they now say that the cooperation clause has been violated in a way that's material to them that allows them to disclaim defense or coverage? And that all, again, flows from the default
Well, they're
judgment.
saying they didn't have an opportunity to investigate and defend, that they weren't told of the lawsuit.
Well, again, the district court in its order doesn't make any findings about that. But the witnesses, Mr. Hunt's still alive, Ms. Jacobs, who was driving the vehicle, is still alive. There's no evidence that the accident scene, that place has been altered. There's a collision report. There's the investigating officer. There's a lot of ways that this could still be defended by Cincinnati if the default judgment is vacated by the, I'm sorry, I've gone over all the time.
You answer questions as long as you get them.
Okay, thank
If
you.
we ask questions, you can finish your answer, and if you get other questions, you gotta answer those as well.
I didn't ask when the time ran out, so I was just apologizing for that. I'm sorry, but the thing is that this default judgment could be vacated by the Court of Appeals, and if that happens, how has Cincinnati been materially prejudiced by a default judgment that no longer exists?
Well, that's not before us.
But that's why the district court, that was its reasoning in issuing its order on summary judgment.
What do you want us to do? What's your bottom line?
I think the bottom line is that due to these issues of efficiency and entanglement and the potential for the order to turn into an advisory opinion that's totally premised on something that no longer exists, I think these orders have to be vacated at minimum and returned to the district court with instructions for our motion to stay the action and let the South Carolina court proceedings play out, or in the alternative, to dismiss, without prejudice for them to refile the DJ action once these issues with the default judgment have been sorted out by
You've
the
made a
state
bunch
court.
of requests there. What do you want us to do?
Vacate the orders. If y'all don't have any more questions, I'll reserve the time for co-counsel. Thank you.
Okay. Mr. Atkinson? Good to have you with us, sir.
It's good to be here. Thank you, Your Honor. May it please the court. My name is Dan Atkinson, and I'm here on behalf of Cincinnati Insurance Company's appellee. I think the first thing and most important thing was already acknowledged by Judge Rushing in the earlier argument is we are here on a final judgment. Cincinnati filed the declaratory judgment action after there was a final judgment entered for default judgment.
You're here on a summary judgment, correct? Not what the judge.
That's correct, Your Honor.
That's what was entered by the district court, and that's an appealable judgment.
That's correct.
So we have appellate jurisdiction.
You do. I do not dispute that, Your Honor. And what I was trying to clarify is the declaratory judgment action filed in the district court, initially in North Carolina, transferred to South Carolina, was filed when there was a final judgment entered against Wayne Hunt in the circuit court for Marlboro County, South Carolina. The motion filed was a
And that's the original lawsuit.
Yes, Your Honor. For ease, I may call it the wrongful death suit, if that's okay with the court.
The wrongful death case.
Yes, Your Honor.
That's the state court case.
Correct. So the wrongful death action, there was a default judgment entered. There is a Rule 60 motion pending, but Rule 60 under the Rules of Civil Procedure of South Carolina is nearly identical to the federal rule in that it is an appeal of a final judgment. There is a final judgment, as noted in the briefing. Mr. Owen's counsel has moved to collect on the judgment. So that's an acknowledgement that it's a final judgment. You don't file a writ of execution unless you have a final judgment. This doesn't go on and on forever. Cincinnati is entitled to findings as to its obligations. Notably, I think the Nautilus factors are not applicable when there's a final judgment. There's not intertwining of cases if there's already a final judgment in the case.
But that judgment is against the driver named Hunt.
That's correct. And
It doesn't involve his employer.
that's correct.
And his employer was the specific insured, the company that bought the insurance policy.
That's correct, Your Honor.
And paid you the premiums for it.
That's correct. The
But
name of
Mr. Hunt is an insured under that policy.
correct. As an employee, the name
He's an
insured,
insured under that policy.
he is covered under the policy, is not a named insured under the
He's
policy.
an insured under the policy. I've read your policy. It says insured, and it says who's insured.
That's correct.
Now, but it doesn't name any of them, but anyway.
Yes, Your
You all
Honor.
talk about names insureds and permissive insureds. I didn't see those terms in there. But he's an insured because he's working for Wilmington, driving that truck when they had the accident. And this young man, 19-year-old man, a passenger in the other car, was killed.
Correct.
So we have a lawsuit.
Yes, Your Honor.
And you all say you didn't know anything about it.
That's correct, Your Honor.
Nobody ever told you anything about it.
That's correct,
What
Your
you
Honor.
say, though, is, when you read it, is you didn't know anything about the lawsuit.
That's correct, Your Honor.
You never say that you didn't know of the accident.
Correct, Your Honor.
And so the record doesn't reveal when and if Cincinnati Insurance had knowledge, actual knowledge, of the accident and the death of this young man. And that the insured Mr. Hunt was the driver of the truck that killed him from the other vehicle.
Your Honor, if I may elaborate on the facts, I'm not sure these are in the record, but I
There's
do want to
nothing
respond.
in here about actual knowledge.
Correct. So, Your Honor,
Was there never any discovery made? I think, right?
correct. Not correct, Your Honor. Cincinnati did serve some discovery in the
All right.
declaratory judgment
You
action.
served
but-
some, yeah.
Yes, Your Honor. If I may fill in, part of the reason that there was not knowledge of the suit is if there had been defense of the suit, and I'm typically a defense attorney, this was the driver of Mr. Owens turned left from a stop sign in front of the truck. It's likely a no liability case. And so that's why
The driver of Mr. Owens,
Mr. Owens'
that's the
vehicle,
other,
the decedent,
and she brought a lawsuit
she did.
which Cincinnati defended
Your
and
Honor,
settled.
there was a default judgment there as well, Your Honor.
Well, it was settled.
Yes,
It's
Your
what- That's the only thing I saw in this record.
That's correct.
Is that the lawsuit by the other driver was settled by Cincinnati Insurance.
That's correct, Your
And
Honor.
if that's wrong, you didn't correct it. But it's in their brief, in a footnote,
That's correct.
early on in the brief. The lady that was driving the vehicle in which the young man was killed.
Correct, Your Honor.
Can I ask you a question about insured under
Sure.
MCS 90?
Yes, ma'am.
It's, my understanding is that the parties are drawing a distinction between what insured means in that form,
Correct.
and whether insured refers to a uniform federal definition, or whether insured means who is insured, how is that defined in the policy? And I understand your argument to be insured means named insured, not however it's defined in the policy. And I wanted to ask about 49 CFR section 387.5,
Yes, Your Honor.
right? So the form is in this subpart of the federal regulations.
Correct.
And a couple sections above, in the same subpart, there's a definitional section,
Correct.
right? Point 5. And point 5 defines, says, for purposes of this subpart, insured means the motor carrier named in the policy of insurance. So it means named insured for purposes of this subpart.
That's correct.
And then within the subpart are the forms, or they used to be. Now it's a hyperlink to the forms.
Yes, Your
But they
Honor.
used to have the forms themselves in there, and they use the word insured, and we then use the definitions to understand that means named insured,
Correct.
right? And
Yes, Your Honor.
that's the reasoning that explains why, for all of these uniform policies, insured means named insured.
Correct, Your Honor. And the Forkwar case, which was cited both by the trial court and in our briefing, goes into that in depth, which was a Maryland District Court case dealing with that specific regulation, as well as the Federal Motor Safety Carrier Administration's guidance regarding that.
Right, there's been guidance in 2005
Correct.
from the agency about that, I think based on this regulatory language.
That's correct. It is interpreting that regulation as to who is the insured, and it is the named entity under that guidance. And the Forkwar case dealt with a driver who was an independent contractor for a trucking company in a lawsuit in Maryland, where you had actually contradictory findings in two lawsuits as to whether he was or was not an employee of the trucking company. And the Maryland District Court said that doesn't matter because the MCS 90 provisions only go to the named entity that is insured, the trucking company.
Following upon Judge King's questions, when do you say you received notice of this?
Notice was received, I was retained about 15 days before filing the declaratory judgment action. That is when notice of the lawsuit
When do
was
you
received.
say the insurance company
That Cincinnati hired me right after receiving it.
and the action brought by the lady who was in the car that was settled, when did you learn of that?
That was part of this declaratory judgment action as well, initially, Your Honor.
So this was a truck that Penske had leased to your insured?
That is my understanding, yes.
WSC. Was there damage to the truck?
There was.
Who paid that?
It is not in the record. I believe the insurer for the driver of Mr. Owens' vehicle did.
Say again?
The driver of the vehicle in which Mr. Owens was a passenger, I'm going from memory, it's not in the record,
They
but my memory
paid
is.
for damage to the truck,
Correct,
the Penske truck,
correct.
not the insurer for WSC.
And I'm telling you that's from memory, so I don't want to say that.
It doesn't follow, because normally when you rent a vehicle, at least in North Carolina and most states, you don't have to buy the insurance,
That's correct.
because if you have insurance, it's going to cover it.
That's
And
correct.
the insurance that was covering this vehicle is your insurance.
That's correct, Your Honor.
Right.
And so when I
So
said the driver,
it seems if the vehicle is damaged, in order for them to get it from, I guess, the injured party's insurer here, it would have to show some liability, but the easiest thing to do is to go and get it under the comprehensive section or whatever, or a section of the entity that leased the vehicle.
understood, and then Cincinnati would have a subrogation claim against the.
But you are certain Cincinnati did not pay that claim.
I am not 100% certain because it's not
You
been
see
an
why
issue in
that
this
might
case.
be relevant?
I do see why it might be
Because
relevant.
if
Your
they
Honor.
paid a claim for a damaged truck, they know there's an injury. Who would pay a claim for a damaged truck and not find out what's going on?
So,
I mean, because I would imagine the damage to a truck of that size would be substantial.
again, Your Honor, I think the important issue here, there's no denial that they knew that the accident occurred.
That what?
Cincinnati knew that the accident
When did they
occurred.
know the accident occurred?
Around the time of the accident, Your Honor, but the issue was the accident on its initial assessment was an at fault of Miss Jacobs.
Huh.
So
Did they go out and try to settle it?
they did not.
Yeah, but I practiced law for a little while, and I remember being in a lawsuit one time where I represented the state bar that had been sued by an insurance company that didn't want, that the state bar had declared was engaged in unlawful practice of law by trying to settle lawsuits early on.
Understood.
That they'd find out about the wrecks, they'd go out and settle, and tell people they didn't need a lawyer, and get them settled. And our unlawful practice committee ruled that that was the unlawful practice of law in the state. And the insurance companies monitored the accidents
Sure.
to try to find out what was going on in order to be able to do that. Get things taken care of early and tell people they were helping them out. And there was a question of whether that was unlawful practice of law or not.
Your Honor.
And I couldn't imagine this 19-year-old boy getting killed with $5 million of insurance on the driver of the truck. And these trucks get a lot of these wrongful death cases, seems like. And the insurer of the truck, the owner of the truck, the driver of the truck is Wilmington Shipping. There's $5 million in insurance, and I could not imagine that Cincinnati Insurance didn't know about that almost immediately. Although here, you say you didn't get notice. And I thought it was very carefully drawn, these affidavits, because you always say, didn't get notice of the lawsuit. Never said, we didn't know of the accident. And when you knew of the accident, your client, you knew there was potential liability. That's when as I'm saying back in my experience, that's when they'd get out there and try to settle.
Your Honor,
Now, I'm drawing on some personal experience, and I've taken some of your time, and I'll make sure you get the extra time back. But I just wondered why this record doesn't reveal when you being your client,
Yes, Your Honor.
had actual knowledge of this accident and the fact that their insured was in it.
Your Honor.
It wasn't Penske. Penske was not your insured.
Correct.
But the Wilmington outfit, Wilmington Shipping, had leased that truck from Wilmington, and Hunt was driving for Wilmington.
Yes.
And this young man was killed, and he's the passenger in the
Yes.
other vehicle.
Your Honor, what I would tell you is there was investigation fairly, I don't know the exact date. I don't put the exact date.
And that's gotta be the biggest claim in the case, the young man getting killed
Yes, Your
in
Honor.
that situation.
And what I would tell you is Cincinnati did an initial investigation and said this is not a liability situation because the other driver pulled out from a stop sign.
Well, you're
and turned
talking
left in
about,
front
you're
of the truck.
talking about what the facts are. You're arguing about the facts, but the special master said there's $5 million in damages. The special master has ruled in the state court
Yes, Your
$5
Honor.
million in damages, which happens to be coincidentally the amount of the insurance.
Isn't that surprising,
And
Your Honor?
so he must have known what the insurance was. So that who the insurer was and those policies must have been well known to everybody. And their Cincinnati Insurance said, we didn't know of anything. Nobody ever told us anything.
Your Honor, let me be clear, because
We didn't
I
have
don't
any
want to
notice.
confuse the record, Your Honor. So, the policy has two notice provisions. One is of an accident, and we've never contended in this case that notice of the accident was not given. The second is notice of a lawsuit, Your Honor. And notice of a lawsuit was never given. I will tell you, there was an investigation done at the time. If Cincinnati thought it had significant liability, it would have retained counsel,
But the prejudice is not the lawsuit. Prejudice, I would
is the
think,
default
would be the
judgment.
default judgment.
That's correct, Your Honor.
And so the question there is, did you seek to set aside default judgment?
Yes.
And you were denied that.
Correct, Your Honor, and let me be clear, Cincinnati split defense and coverage
So
as is
if the
required to.
default judgment had been set aside, then it's a different case.
It is not, Your Honor. Under the Great American case, North
Well,
Carolina
if you
State.
saw that, if you went in and says, well, we've been prejudiced because of this default judgment, and the state court then sets it aside for you,
Yes, Your Honor.
then it's a different case.
Your Honor, it is a different case factually, but the prejudice analysis under the Great American
So
line of
you think you
cases.
still would be prejudiced if the state court had granted you that relief that you asked for?
Your Honor, I believe Cincinnati still would have a defense to coverage if it had obtained that.
Why would you ask for it? I mean, why would you ask for it and to set aside? If you're gonna be prejudiced anyway, one way or the other, I mean, just go in and say, we're not paying because we didn't get notice.
Because it's doing it under reservation of right. There was a reservation of rights letter issued stating, we will seek relief from the default judgment, but even if it's granted, we do not believe we have coverage obligations, and we are filing a declaratory judgment action in this regard. I wrote that letter, Your Honor. So I'm well aware of what that one says.
So you're in both lawsuits.
No,
You're-
no, defense and coverage is split. I'm coverage. There's different counsel handling defense, Your Honor.
What happens if the appeal court does set it aside?
Then the judgment's no good because there's not good service, and the statute of limitations ran in 2016, I believe, Your Honor.
So it doesn't mean, if you set aside the default judgment, it doesn't mean the original complaint is still in place and you just go, it proceeds on now to trial. Because, I mean, nothing, if you set it aside, then you got the original action, don't you?
So, Your Honor, the basis to set aside default, at least my understanding of the pleadings, is that service was bad. Under rule, I believe it's 3, I don't have it in front of me, the South Carolina Rules of Civil Procedure.
The issue on appeal is the service of process issue.
That is my understanding. Again, I'm not appeals counsel.
Well,
that
but
would do it.
you're their lawyer here that's got to answer the questions.
Well, I'm not representing,
We're entitled to know. The service of process issue is on appeal in the Court of
Correct.
Appeals of South Carolina.
that is my understanding. I was aware that the judgment was
But you
denied. I
don't
have
know.
not seen the,
You're telling us you don't know.
I have not seen the Court of Appeals filings, Your Honor. I'll be honest, I have not seen those. Again, I'm not defense counsel. That was not communicated to me. But the issue, I know that the issue in the underlying motion to set aside default was service of process.
Well, you know, the South Carolina Supreme Court of Appeals could decide to set it aside and says, well, the reason we're setting it aside is because we didn't include, you need to include the insurance company on this, or, I mean, if it says something like that, you got a different case, don't you?
Your Honor, that's not a basis under Rule 60 to set aside a motion for default and default judgment under South Carolina law. It has to be fraud, mistake, error of law.
I think you're right. If it's on service, I don't know how you get over the statute of limitation. Maybe the other side can tell me on that. I brought that up, but that's, you guys brought a heck of a piece of litigation up here with a lot of the issues I've never seen before. On a $5 billion case, it makes no sense to me.
So, Your Honor, I agree with you on that issue. I believe that there are two options with what happens on the underlying case. Either default is set aside and there's no case remaining because service was not completed within 120 days of the statute of limitations running.
So the South Carolina the wrongful death litigation is incomplete.
I disagree with that, Your Honor.
Well, it's on appeal in South Carolina.
It's on appeal of it's on appeal of a Rule 60 motion, not a Rule 60 motion to change a final
It's on
verdict.
appeal in South Carolina.
Correct.
Okay, so but you're saying it's, that appeal's frivolous or something?
No, Your Honor.
That's the reason it's complete? You're saying it is complete?
Your Honor, the reason
You're
it's
saying the wrongful death case, that you called the wrongful death case,
yes.
is complete?
Yes, and this is the reason, Your Honor, is what is on appeal is a Rule 60 ruling, which is a motion to modify a final judgment. It is not an appeal of the judgment. It's an appeal of a motion to modify the final judgment. What I would say further indicates that it was a
I
final.
thought you said it was on appeal with respect to this service of process thing.
That's the basis under
Well,
rules.
if there's no service process, there wouldn't be anything.
The suit would be time barred, Your Honor.
Well, that's what, yeah.
Yes.
But so it's not complete. That's back to my question. The wrongful death case,
Your Honor,
if it's still pending in the Court of Appeals of South Carolina, according to both the lawyers, that's one thing y'all agree on here.
let me pose it this way. There was a final judgment order entered in South Carolina.
Well, there was a final judgment order entered in this case. That's why it's on appeal here today.
But here's the critical distinction between that case and this case. That final judgment was not appealed within 30 days of the entry of the judgment. A motion under Rule 60 was made just short of a year after entry of the judgment, which is, as you know, the deadline for a Rule 60 motion, to set aside a final judgment due to apparent failure of service of process. Cincinnati takes no position on whether service of process was good or not. Cincinnati says there's no coverage either way. If service of process was not good, then there is no judgment because there's no jurisdiction over the defendant. There's no judgment. The statute of limitations is expired.
I hope some of our students are listening closely to this because it sounds like a bar question to me, this case presents, but Mr. Hunt is on the hook for $5 million. He was sued, is that correct?
He was sued, and he's in default in this case.
Has he brought an action against his employer? I mean, he's in an employed status. I guess he's in the scope of his employment, the whole bit. Seems like to me he'd bring an action. He's got $5 million to pay. Whether he can pay it or not is another question, but you got a judgment, $5 million. And he's working for someone who has insurance. And there could be no way Wilmington didn't know of the accident or probably even of the suit. I mean, you would follow it up. I mean, I don't know what's going on. I know that's an outside question, but it's still, it begs what is going on in this case because there's a $5 million judgment, and this is against Owens for a declaratory judgment in terms of whether or not they can receive it under default.
Correct.
But Hunt, they're entitled to $5 million. They just can't collect it probably from Hunt unless he wins the lottery or something like that
Sure.
happens with him. But he seems to me has some action here against somebody. You employed, and in your employment, a $5 million judgment is levied against you. I don't see how you keep Wilmington out of this action.
Your Honor, Mr. Hunt would have had to have given notice to.
But Mr. Hunt was an insured of your client. Well,
He was insured under the Cincinnati policy,
he
yes.
was insured, he was an insured under that policy,
Yes,
absolutely. And he's got a $5 million judgment.
yes, Your Honor.
And you're saying you can't be charged with paying for that judgment because he didn't give you, or Wilmington didn't give you proper notice of a claim and a lawsuit that your client already knew about.
No, Your Honor, I don't
They
agree
knew
with that.
about the accidents, you have told us that.
They did know about the accident.
They knew about the accident, and if you've got an accident where a 19-year-old young man is killed on the highway in South Carolina as a passenger, you know very well there's going to be a big lawsuit.
Your Honor, I must disagree
I mean,
there.
I didn't come over on the pickle boat.
I'm not accusing you of that, Your Honor, but again, the accident report is in the record. If someone runs a stop sign and pulls in front of a truck, an insurer is not on notice that they're going to be
Well,
sued.
you're talking about the merits of the lawsuit, which you didn't defend. But
Can I ask you about the briefing in this case?
Certainly.
Did the appellants question the substance of the summary judgment ruling? I don't see anywhere in their brief where they argued that you were on notice and therefore the substance of the summary judgment ruling was wrong.
Thank you, Judge Rushing. They did not file anything in opposition
So
to
there's
the
nothing
summary
about
judgment motion.
notice and when you knew it. There's no dispute about that on appeal.
And may I
Is
add?
that right?
That is correct. And may I add, the trial court judge has very strict rules, which I have come to understand and appreciate, for summary judgment motions where the parties have to confer on facts, file a notice of
You're talking
agreement.
about the trial court.
In this case.
The federal court.
Yes.
Not the wrongful death case.
Yes.
Okay. Yeah.
Has very strict rules. There was no opposition to any fact asserted. There was no argument in any form in opposition to the motion for summary judgment. And I would argue that many of the arguments made here are being raised for the first
Well,
time
there
on
was a
appeal.
motion for, to file an amended complaint.
Correct,
And a motion for, and to stay the proceedings,
correct.
because of the pending wrongful death case in South Carolina.
So I will quibble with you a bit, Your Honor. There was a motion to stay the proceedings. They had already filed a writ of execution on the wrongful death case, so it would be hard to argue it's pending if you've moved to execute on the judgment, Your Honor.
Well, they're trying to collect.
Correct.
I mean, all right.
So my point being, they're arguing it is final there by filing
Well,
a
you're
writ of
saying it's not
execution.
even final now, it's on appeal.
Your Honor, I've said all along that a Rule 60 motion means it is final. You can't file a Rule
No,
60.
but there was a motion to amend the complaint
Yes, Your Honor.
and to stay, which was denied.
That is correct, Your Honor.
And that's on appeal here.
Yes, Your Honor, and may I address that? I know I've gotten way late and I'm over. May I address that very briefly?
Go ahead.
Okay, thank you, Your Honor. The reason the motion to amend was denied, there are two important points to remember. One is the MCS 90 issue, which I think the law is clear on, is that it applies only to the named trucking company. Two is, this is a declaratory judgment action, and the MCS 90 issue was raised as an affirmative defense, so no amendment was necessary. It's already pleaded. They were welcome to conduct discovery. They conducted no discovery in this case, and they cannot now complain they didn't have an opportunity to do so. If there's nothing else, Your Honor, I thank you for your time.
Thank you very much, sir.
Thank you.
Let's see, Mr. Luck, you're going to finish up here?
Yes, Your Honor. Thank you very much. So to start with,
Good to have you with us.
very good to be back, Your Honor. To answer a question from Judge Rushing right from the beginning here, this is what we're dealing with here at the state court level is a final judgment until it's not a final
Well,
judgment.
tell me what is your best case saying that we have to, there's no declaratory judgment action jurisdiction in a federal court over a duty to indemnify unless there's a final judgment that has been upheld on appeal and the motion to vacate's been denied and that's been upheld on appeal and cert's been denied. What's your case for that?
When we get to asserting
And
jurisdiction.
what's your case for that?
Again, so we're talking about asserting jurisdiction in that circumstance, the circumstance
That's
you
what
described.
this whole appeal is about, believe it or not.
Correct.
It's about the declaratory judgment action.
An entanglement. So what we have here, yes, there is, what's the argument against the district court exercising declaratory judgment jurisdiction over this matter? Do I understand that correctly?
No, I'm asking what's the legal standard? The very highest one that I can find is Trust Guard, which says that if there's a motion for a DJ while the insured's liability remains undetermined, then maybe the court doesn't have jurisdiction or shouldn't touch it. But here, liability has been determined,
Correct.
right?
Well, it is, until it isn't determined, it has
But
been
it's been
determined.
determined, and that was the question in front of the district court at the time that the DJ action was pursued. And there was a final judgment, the liability was determined.
So Trust Guard and the
Yes.
authorities, yes, Your Honor.
Okay.
The authorities that Trust Guard states, though, show that that jurisdiction under these matters, it's not a given at any time. The courts do have
I mean,
the
there are
ability-
cases that are less stringent than Trust Guard. We have other decisions from this court where we've said even while the underlying, action is pending, you can
Right.
get DJ. So, I mean, it only gets worse for you. I don't know of any authority that goes beyond Trust Guard, but if you know of some, please tell me now.
Well, look at Trust Guard and look at the issue of
So that's,
entanglement.
you don't know of any.
I don't know of
other
any
ones.
right now in front of you, Your Honor, but look
Okay.
at Trust Guard and look at the issue of entanglement, because that's where you're comparing this case with Trust Guard. Trust Guard, yes, the underlying action was at an earlier stage. This one's at a later stage. However, in Trust Guard, the issue of entanglement was less prevalent. Here, it is extremely prevalent. We have an issue where we're talking about service of process. This issue of service of process is a thread that runs through both of these cases. This declaratory judgment action doesn't proceed if there is not service of process.
I just didn't see service of process as an issue in this case at all. The insurer didn't raise it. It was never, I know you tried to make it an issue in the federal action, but it seemed totally relevant.
The insurer didn't raise it below or in the declaratory judgment action? Because-
Here, in the declaratory judgment action, service of process on the fella in South Carolina didn't come up.
Well, he was in North Carolina. We're talking about Wayne
Right.
Hunt, correct?
Yeah, he
Yes.
lives in North Carolina, but the accident happened in South Carolina.
And so the issue there is was he served properly with the underlying suit papers? And so because that issue, if he is not found, if the service of process is not proper, there is no valid and enforceable judgment at the state court level. Without a valid and enforceable judgment, there is no declaratory judgment action.
How are you
Because,
gonna get a judgment at this point, statute of limitations run?
it's an interesting question, Your Honor, but this is in the Court of Appeals. They have a lot of flexibility in how they may resolve this. Yes, what's before the Court of Appeals, which I'll be handling that appeal.
Find me one case, I practice law, where the Court of Appeals will say you did not effectively serve process, but I'm gonna give you without prejudice to now go and do it. 10 years after an accident, over 10 years later.
What can happen, Your Honor, is the order can be set aside.
Give me one case, even close to saying what I just said.
There's one in my head right now. I'll have to send it in supplemental briefing, but I'm happy to send it to you.
I
There
would love
is-
to see it,
Because, and it's
because
not,
I've never seen anything like that.
it's not on all fours, Your Honor, but the idea here is, this is an order on appeal, underlying case, an
Okay,
order
you
to
set aside that judgment.
Set aside
For the
that
reason
judgment.
it wasn't properly served, that then says there's nothing that's been told anything. You then have to file an action now. I don't know how you're gonna do that, even if the Court of Appeals, I don't think it's ever gonna happen.
You're also presupposing that just setting aside that order of default also invalidates service. I know these can be separate creatures. You can make a voluntary appearance.
You said it was defective service.
It is effective service, but if the court of,
Defective service.
if the Court of Appeals finds service was defective, they can still find
Isn't that
that
the
someone,
basis you're appealing on, to say it was defective?
of course.
So if they find it's defective, you don't have anything. You don't have an action at all.
Underlying, correct, and there's
So
also
you
no,
gotta file a new action.
which we can't do,
You can?
cannot, because the statute of limitations is
Well,
run.
it's the same thing. I don't get it. So what are you gonna get? If
So-
they set that judgment aside.
Correct.
You don't have service, you can't file an action. How in the world are you gonna get them to pay you anything if you don't file an action?
Let's separate the two issues of setting aside the judgment and service. These
No,
two,
I want to separate two issues of setting aside the judgment and the new action.
well,
Because you say the service is defective.
if the service is defective.
Yes, which would be the basis for them to set it aside.
Correct. That does not preclude them from finding there was a voluntary appearance before the court, excusing service. You see where this is?
Well, then that would be a basis for upholding the default judgment then. if he's made a voluntary appearance, and they said that's effectively saying he's there.
So frequently, in the past, in trial court matters, not necessarily on orders of default, but on entries of default, where service was questionable, I have more than once in the trial court seen a trial judge set aside the entry of default, and even though service was questionable, nonetheless ruled that service was proper. So, counsel, proceed with your case.
All right, one last question.
Yes, Your
which
Honor.
is sort of not dealing with, but the 19-year-old was a passenger in this car?
Correct.
Of, the driver?
Correct.
I take it they sued the driver?
If I remember correctly, I do believe there was a claim made against the driver of the car, but I do not.
You don't know if you ever, this is state that you're representing now, you have no idea if that state ever recovered anything from that driver?
I don't want to speak out of turn, but I have a feeling it's possible. Bear in mind, this is decades
Well,
old, but
you heard your counsel on the other side say that it was that driver's insurance that paid for the damage to the Penske truck, is that correct?
that's the first I've heard of that, but it wouldn't surprise me.
Who's doing investigation of these cases that you wouldn't know that answer? It would seem to me, even in where you are, it's more to the point of curiosity, is why don't you know whether or not this state has collected money? You just took the action, don't look what's done on the line, or whether there's an action that's been filed against the driver of the car, whether the driver paid for a Penske truck, because it seems as though it's all pointing to the liability of this driver, but then there's a settlement with the driver, potentially. We don't know about that either. But it would seem that all indicates everybody thinks this driver did it, so no one tells the insurance company anything. And it goes on, but you go in and get a default judgment against the driver of it, who is not the employer, and it's a default judgment because he didn't show up, and you got a $5 million judgment. Now you backdoor in and get liability against the Wilmington people based upon that default judgment. That's the only reason I can see why this was done. It was a backdoor way of how to get liability in the case you probably couldn't have gotten it by filing the action against the actual person that's into the insured. You see what I'm saying?
I see.
I mean, that's the only way, only reason I can see it. You backdoored into a liability situation and said, well, we just served Hunt, he's the driver, and he didn't show up, you didn't know anything, went and got you a nice judge to give you a default judgment for $5 million, nobody knew about it. Now I'm gonna go against this entity. I didn't even tell them I'm filing this, because I didn't want to tell them, because I'm trying to get a default judgment. I really want a default judgment. I don't want a trial on this, because I might have already recovered against the driver of the car, because the liability probably is there. In South Carolina is a contributory negligence state, right?
Comparative.
Comparative, yeah. There's only 4 of them, yeah. So, yeah, well, you got that too. So,
So, Your Honor, I would.
but this is not your case you brought. So when I bring those things up, I'm not assessing any of this. I'm only assessing what you know before us now.
And what
It would seem to me you would know the answer to those questions, but
now,
because they're more than interesting, that seems to indicate some basis of why this all happened, because you just can't figure out why it happened.
well, the record does reflect does provide some information as to why Wilmington Shipping Company is not part of this. And it's both in the special referee's order and in some of the pleadings throughout the record there, and that is the use of this leased vehicle obscured their involvement in this. And so, in effect, when this was originally filed, the employer was unknown and could not be known. The only
lease
person.
contract? You get the lease contract?
Obviously not.
Have you looked at it?
I have not seen this lease
Somebody
contract.
could
Don't even
ask
look at the
Mr.
lease
Hunt
contract.
who he worked for. You said they couldn't find out who the owner was, or who the driver.
I think it would be
Mr.
fantastic.
Hunt
It would
knew who
be,
he worked for.
it would be
Well,
fantastic to ask Mr. Hunt who he worked for, but he went into default. He was served, and he chose not to update his records with the North Carolina DMV, so that he didn't receive it, or he did receive it. I don't know. Either way, he was served under South Carolina law. He was deemed to have received it. He chose not
That
to
truck have
participate.
written on it Penske.
I wished I had a picture of it, Your Honor.
You don't know that either.
No,
Okay.
you're-
But if it's got written on the Penske, you sue the driver of a Penske truck, and you know that that truck is leased, Penske's a leasing company, and nobody went to Penske and say, okay, because he could have gotten insurance with Penske. I mean, Penske, you can buy an insurance policy. So either his insurance took, well, let me ask this. Does he have insurance?
Apparently, he did not, Your Honor. I saw
He
no
doesn't even
record.
have motor vehicle insurance himself.
Even if
Because
he
if he
had,
did, that's another source of income that his insurance would have to pay because he's a driver.
very likely but if he's driving for business, I don't think they would
But
cover
you
it.
don't know the answer to that question.
But if I don't know that answer, but I can say with a certain amount of confidence that if this was if he had a personal drive policy for his automobile, it wouldn't pay, because he was driving
But the
for
question
his
whether or not it
business.
would pay, I just want to know, did he have a policy on it? Because if he did, then that insurance company would have some interest in saying, hey, we want Cincinnati in this too.
Well, then you see, we could look at
But you don't know the answer. I mean,
I know what is in the CR 310, which is the collision report that's in the record. You can see that lists what we do know. That was the universe of facts available at the time of filing. So you have to work with what you have, and that was what was filed. That's how it was filed. I see that my time.
Thank you very much.
Very much up. Thank you.
Your time's pretty much expired there, yeah.
Thank you.
Thank you
Your
very much, Mr. Luck. Thanks all three of you, and we're gonna come down to Greek Council, and then I'm gonna exercise my discretion and take a quick break.
This honorable court will take a brief recess.
I like that.
And our next case is United States versus Good. Mr. Simperboyd? I messed it up.
That's okay, Your Honor.
I'm sorry.
You're not the first. Good morning, Your Honor. Steve Van Stempfort for Mr. Good. And I think I've reserved 5 minutes for rebuttal, if that's okay. So we have a couple issues here, but I think, first of all, I want to talk about the appellate waiver. The government's either forfeiture or waiver of the ability to rely on the appellate waiver that Mr. Good signed. I think the Kemp case is pretty close to what we have here, except this case is actually kind of even more exaggerated in terms of what the waiver or the forfeiture is. So here what happened is that Mr. Good, we filed the opening brief, and then the government, on the day that its response brief was due, filed a motion that was in 2 parts. Was partially on the motion to dismiss on the basis of the appeal waiver. That was directed at the constitutional argument that Mr. Good raised. And then the second part of that motion was a motion for summary affirmance, and that was on the ACCA argument. It's essentially the summary affirmance said, look, we want to get rid of this thing on the merits, right? The ACCA argument. This court, of course, granted the motion to dismiss on the constitutional argument and it deferred on the summary affirmance, set it for full briefing. And then what the government did is it said, okay, now that we have to brief it, actually let's go ahead and try to move to dismiss on the appeal waiver with respect to the ACC argument as well. And I think the Kemp case, I think, is pretty clear. Look, if the government has a chance, right, and files a motion on some grounds and then intentionally decides not to file a motion on other grounds, those other grounds are forfeited. And here I think actually here's a pretty good case for waiver, because the government specifically said we want to enforce the appeal waiver with respect to half of the appeal, and then didn't enforce it with respect to the other half. And so I think we're in waiver territory. If it's clearly forfeiture, but I think it actually looks like waiver. Again, I would direct the honors to the Kemp case, which again had to do with a timeliness bar. So they're in Kemp. What the government did is they filed a motion to dismiss based on the appeal waiver, and then later on said, okay, actually, let's try to dismiss this thing as untimely. This court ruled they forfeited the argument. And I think the same analysis applies here. So that's with respect to the appeal waiver, that part. And then the second part, of course, is the merits. And again, this is plain error review on the ACCA argument.
You recognize it's plain error.
Yeah, the review is, yeah, absolutely. The standard review is plain error, yes.
How do you satisfy?
Pardon me?
How do you satisfy plain error?
It is an uphill climb, Judge, I agree. But I think we can get here this way. Because I think, one of the interesting things about the ACCA, of course, is that you end up with kind of strange outcomes. And it's interesting,
What about with plain error, we may not even have to get to the ACCA. There's the substantial rights prong of plain error, and wasn't your client subject to 360 months regardless? Isn't there another count where he got 360
Yes.
months?
Yep.
So how are his substantial rights affected by this, even if we assume this is error, and even if, we take a drastic step of assuming it was plain, he would still be subject to 360 months in prison, wouldn't he?
Well, so yes, he would be sentenced to 360 months on count 1, but not on count 5.
Right.
And I
But
do think
they were concurrent, right?
that's correct.
Okay.
Right, and there's the Foster case, but I think Foster is pre-Pepper, right? So I think we can distinguish it on those grounds. And I do think,
Well, Pepper is about if the sentence is being vacated on one count, then the court can reconsider the whole package. But nothing would be vacated in this circumstance. I don't see how Pepper changes anything for you. Here we're talking about here we're talking about should we vacate, right? We're pre that step in the process.
Right.
Pre-Pepper.
yeah, well, I think that's true, Your Honor. And I think the question is, if the court says, okay, let's assume there was error, let's assume it was plain, and then we get to, did it make a difference? And clearly it made a difference on count 5. Now, it didn't make a difference in terms of the total amount of time that he spends in prison as of right now because of the 360 months on count 1. However, I think his and if we play it forward, right, and I think, so I think this is actually an important point for defendants who've been sentenced of multiple counts, because you never know what's going to happen in the future with respect to the sentence on the other count, right? There may be something that comes along the way and there's a retroactive effect that reduces that sentence for some reason, right? Then you'd be in a position if this court said, look, we don't think his substantial rights were, challenged, were affected because of the concurrent counts as of right now, then what happens to him later on, right? Because then later on, you're in a position where potentially they would have affected it based on what happens with count one, right? And again, I recognize this is all kind of theoretical in some respects, but I think it's an important point for purposes of this court's jurisprudence to not lock into a rule where if there is concurrent counts, necessarily the sentence, if you are sentenced above the statutory maximum on another count that's concurrent, necessarily there's no substantial interest. Because I think there is a substantial interest in being sentenced correctly on each specific count, because again, you never know what's going to come down the road. I guess that would be our position on that piece. On the error itself, and again, I recognize this is an uphill climb. I do want to.
You just said you recognize.
I do realize it's an uphill climb on the, there's a hurdle here.
Previously, your earlier statement is your client has 360 months, and he's going to have 360 months no matter how we rule on this case. Is that right?
On count one, yeah, but not in count five.
But he's still going to have 360 months.
Yes.
And so there's no, what you now is trying to, just in case in the future, some miracle or something happened from the Supreme Court that says, the other one is bad, but you won't be stuck with 5 or something like that you're trying to say.
Well, there may be legislative acts, down the road from Congress, right? I mean, sometimes what happens is they pass a statute that retroactively, knocks down the sentence for some individuals in some circumstances, right? Whether that happens now, I have no idea. All I'm saying is there is an interest in a defendant of having each sentence be appropriately within statutory maximum, right? I guess that's the only point I want to make with respect to the substantial interest affected, right? Because yes, he's, in terms of the amount of days he spends in prison, yeah, count one is out there, right? But on count 5, he has an interest in being sentenced correctly on count 5 as well.
Do you recognize our Ellis case says, unless it's going to reduce the overall sentence, it hasn't affected substantial rights?
So again, and I can't remember if Ellis is before Pepper or not, but again, and I recognize that, there are issues, right, in terms of practicalities, in terms of whether somebody's substantial interests are affected. But again, I think a substantial interest on a count-by-count basis is important for the particular defendant in this particular circumstances.
But what Judge Rushing is saying is, we do have cases that are on point on this, and basically says that there is no substantial right interest where you have the concurrent sentence like this, and one is out and you still have the same sentence. So
and
for us to do something different than that, we'd have to have an en banc, or the Supreme Court would have to do something. But we cannot, this panel cannot change that precedent.
Correct. And obviously, Your Honors, you are bound by the precedent, and to the extent that it applies here, it applies here.
So you understand, you lose on that issue here, but you are asking for what are you asking for?
Well, Your Honor, I think what I would do is I would go back to the first argument, right? I think the first argument in terms of the government's waiver of the appeal waiver, I think that is clearly, I think that's pretty open and shut in our favor.
Well,
then
you
on
waived the appeal, and so you got the merits here.
Exactly. The
You
merits.
lose. You still lose. I mean, you lose. What difference does it make whether or not they waived it or not, if the end result is the same?
Well, I think the principle that the government, if they file a motion for summary affirmance, right, and they intentionally say, look, we're not going to worry about, the appeal waiver for purposes of this argument, I think that's an important principle for this court to recognize, right, regardless of what happens on the merits. I think that laying down that rule, because, when I saw the motion come in for summary affirmance, I thought.
Got that. So basically, you want an opinion that will express that, but it's not going to help your client.
You want us to say there's no what do you call it, a summary affirmance, but you lose anyway.
Your Honor, I can't acknowledge that I'm,
No, but
you know, I'm working with what I have, Your Honor.
You want to say
obviously.
they forfeited it? then?
Yeah, absolutely.
That's
So,
what you want us to say,
so-
yeah, but even with that, you still lose.
as I indicated earlier, Your Honor, I realize that
it's just a question of which prong you lose on,
in terms of the plain error,
in terms of plain error.
there are challenges at multiple prongs. Yes, Your Honor. I will concede that it's
Yeah,
a difficult
if we-
argument.
If we would think, well, maybe there was an error, we assume there's an error, but as complicated as could be, it doesn't jump off the page, and it's not plain error, so you lose right there.
And, you know, I recognize it is a complicated issue, and it is interesting, you know, if we look at the North Carolina statute that he was convicted under, it's a one big paragraph, it's in our brief, but actually felony murder under North Carolina, under that statute, felony murder is a first-degree murder under that statute, and felony murder is not a crime of violence under this court's analysis in Jackson. And so we have a really weird situation here where it looks like by pleading guilty to second-degree murder, instead of being convicted of first-degree murder, he's actually convicted of a crime of violence, whereas if he had been convicted of first-degree murder, he wouldn't be. And so you do have this very odd situation where first-degree murder under this particular North Carolina statute is not a crime of violence, whereas second-degree murder is. And again, you know, I recognize that this court's precedent is what it is, but that is a very odd situation. But to answer Judge Wynn's question, I think yes, we would ask for an opinion or precedent here establishing that when the government moves for summary affirmance and does not choose to move to dismiss on the appeal waiver, then it has forfeited or waived the appeal waiver and can't resurrect it later on when a summary affirmance motion is denied. Unless there are further questions, I'm happy to cede my time.
Thank you very much.
Thank you so much.
Appreciate you. Ms. Englander?
Good morning, Your Honors, and may it please the Court. Kate Englander on behalf of the United States. This is a case where the standard of review, plain error, should be dispositive. Even if the defendant could show that North Carolina's second-degree murder is not a crime of violence, and we absolutely contest that, we believe it is a crime of violence, but even if they could show that it's not, the defendant can't show that that is a clear and obvious conclusion under the law as it stands now, nor can he demonstrate that it affected his substantial rights where it didn't impact the guidelines range calculation of the district court, nor did it impact his overall sentence from the district court because he was sentenced to a concurrent sentence of equal length. And I'd like to just jump in and start with that last substantial rights problem because I do think it's decisive here. Again, it did not, the designation of the defendant as an armed career.
The one in which we've got cases on that basically said that when you have these concurrent sentences, you lose those substantial rights?
That's right, Your Honor.
You don't say something different in those cases?
I don't have anything different to say. I would just.
I'm not trying to cut you short, but I mean, I don't think you need to relitigate something that you probably could just quote us from those cases. And you probably pretty good arguments. Sounds like to me.
I would agree with that, Your Honor. I think Foster and Ellis are conclusive here. So if the court has no questions on substantial rights, I'm happy to move on to plainness. You know, I would just point out that there's nothing plain and obvious about whether.
Can I just, you're moving, you've started with the merits, so I'm
Yes.
assuming that you don't have anything to say about the waiver forfeiture of the plea agreement.
Your Honor, I'm happy to make a few points on it. I do think the merits.
It's fine if you don't.
The merits here are straightforward, so I'm happy to address it on the merits. I think the government filed its motion recognizing that it was out of time, filed a second motion to dismiss because there was a significant change in the law that impacted whether or not defendant's claim fell within the scope of his appeal waiver. The Lubkin decision was, you know, I think a significant clarification that the government was frankly not anticipating when it filed its first motion.
I usually hear that argument on the other side. And I don't think that case, it doesn't seem like to me it fits in there, and even if so, there wasn't a sea change. It wasn't a sea change in the instance that it was clear that what you did was what you did. because obviously the government did it in the Lupton case too. I mean, so, you know, I mean, it was just something you probably should have done. You probably should have included in with the motion to dismiss, but then to ask for some of the affirmance of it. I mean, we do this with defendants all the time in terms of waiver on these kind of cases here. But I think if we write it or go in your direction, it certainly will change the law in terms of how defendants approach this and what they have forfeited and what they waive on cases. Because what applies here applies there. So if you think that's a case that really did do that, there are a lot of other cases out there that are sort of similar to what it did. And yet this court, it was not so clear that was the direction to go, because, I mean, most people look at second-degree murder, you probably says, well, of course, that's a common sense, but it's not a common sense analysis, it's a categorical one. So that's, but you know, so, I mean, it just seems like any prosecutor would, the first thing says, oh, no, this is waived, you know, because it's just, you know, not there. But whoever made the decision, it probably was not one that you usually make there, I would probably say. I would dare say you probably have done that in other cases.
Sure, Your Honor. I'll just make a couple of quick points here, and then I'll move on. I think, frankly, we do think it is forfeiture, not waiver. And if it's forfeiture, it's within the court's discretion to excuse the late filing. That's all we're pointing out. You know, I do think that this case differs a bit from Kemp and Oliver in the sense that Kemp was a case where the government had completed full merits briefing and had sort of missed the issue that the case was not timely filed, and then later filed a motion to dismiss. It was, you know, apparent. What the court said there is basically, you wasted our time by asking us to review the full merits briefing before you then filed this procedural motion. Here we did, you know, we had an initial motion. We had not fully briefed the merits when we filed our second motion to dismiss. I recognize that it's not a major distinction, but it is a distinction. And, you know, I don't think that there's any doubt that the government, had Lubkin been decided before our response was due, would have moved to dismiss on that basis. This court already found that the plea in this case was knowing and voluntary when it dismissed the other part of this appeal. And this claim is, I believe, within the scope of this court's decision in Lubkin. That's really all I want to say about it. I do think this case is straightforward on the merits. I'm happy to further address it on that basis. And I think especially looking to plainness in this case, again, the parties have spilled a lot of ink on the various cases in this area, on the categorical approach, arguing that the cases point in different directions, Castleman, Rumley, Manley, all of these cases. I think that alone precludes a finding that this was not, that is plainly a crime of violence. This court itself has 3 times held that it is a crime of violence, all in unpublished cases. We recognize that. I recognize that those cases predated the Borden decision of the Supreme Court that sort of changed a little bit the understanding of the mens rea requirements. But they post-date Leocal, so it was definitely recognized at the time that those cases were decided that there is a mens rea component to the crime of violence analysis that needs to be considered when you're evaluating whether a state court crime is categorically a crime of violence. And I think just if we take a step back, you know, I recognize that the analysis can be complicated, but I think both this court and the Supreme Court in Delegati have recognized that murder is the prototypical crime of violence. And I think Irby described it as the quintessential crime of violence. So I think just taking a step back, again, we're talking about second-degree murder. How could it be plain and obvious, unless there is a direct case on point, how could it be clear and obvious that that's not a crime of violence? I don't think the defendant has met their burden there. And then really turning to the actual merits of it, the error prong, I think that the defendant, Borden left open the question of whether a mens rea of extreme recklessness, which falls somewhere between recklessness and knowledge, is sufficient for a crime of violence. It explicitly left that question open in footnote 4, I believe, of the Borden decision, but that's not an open question in this circuit. So the Manley decision said extreme recklessness, and they're analyzing a Virginia version of it, but it's substantively identical to North Carolina's definition of malice. And they said that that is sufficient for a crime of violence. And Your Honors, I do want to just kind of briefly address the Parley case, because I think that that is, that's the overdose that resulted in death that I think is really what defendant's argument on the error prong hinges on. And I do think that there are some points to make about that. So first of all, that is a Court of Appeals case in North Carolina that was decided on sufficiency of the evidence. So the evidence is interpreted in the light that's most favorable to the state in that case. I think it's important to recognize the court did not lower the mens rea standard in that case. It said that the prosecution had to prove malice. And we can't say based on these facts that a reasonable jury couldn't have found that met here. It's a very limited recitation of the facts. And there are some indications, even in that limited recitation, of how the jury could have come to that conclusion that there was malice there. The defendant in that case, indicated that the pill that he was distributing was very dangerous, that he liked to take it because it messed him up. And we also know that the victims in that case were between the ages of 13 and 16, which may have played into the jury's understanding of how inherently dangerous that action was. And Your Honors, I think if there are no further questions, I will reserve the rest of my time, but I'm happy to answer anything about the merits.
Thank you very much.
Thank you.
We appreciate your work. Mr. Templer?
Thank you. Just a very short rebuttal, Your Honor. In terms of the substantial rights prong, LS looks like it's a 2003 case. So again, our position would be that along with Foster, predates Pepper. Again, which instructs that you look at the sentence as a whole. I recognize that there are concurrent counts here. I will also point out, though, that the government at sentencing the first time around recommended 300 months, which is lower than the 360 that he actually received. And so if there was error, if it was sent back, there is a possibility that the district court would sentence along, consistent with the government's recommendations, which would be lower. And again, Your Honors, to the extent that this is resolved, that the plain error, the merits is resolved against us, I think that this is not the prong to do that on, for the reasons I mentioned earlier, right? I mean, because there may be consequences downstream from saying, look, right now you're sentenced to the same thing, and let's just kind of
You'd rather us decide it on plainness. That's not plain because we've said in previous cases this is a crime of violence.
Well, I think Manley is out there. Of course, we've said that Delegati changes the analysis. I think it's difficult to square the extreme recklessness analysis with Delegati. It's really difficult to show how an act by omission, if it's just reckless, even if it's extremely reckless, how that could result in somebody using something as a conscious or force as against a conscious object of that force. So that's our position. To the extent that the case is decided, though, I would agree that it would be decided on the plainness prong rather than anywhere else. Unless there are further questions, Your Honors.
Thank you very much, sir. And we recognize that you're court appointed, and I want to say how much we appreciate your work. We couldn't do ours without lawyers like you.
Thank you, Your Honor.
We'll come down to Greek Council and then take up the final case. Is United States versus Gentner. Mr. Foster.
Good morning. I'm Rick Foster. I represent Greg Gentner in this case, and I'd like to start.
Now, are there two appellants in this case?
There are two appellants.
Mr. Brasler, what is that?
Yes, sir, and Juan Chartier is here.
All right, he's represented too.
Yeah, I intend to take the first 6 minutes and then some rebuttal time.
Yes,
I-
but we have two appeals here.
Correct. And on the briefs, which were consolidated, I prepared issues 1, 3, and 4 of the appellant's issues, and those are what I intend to argue today. I don't intend to argue too much unless the court has questions on issue 1. But 3 and 4, I think it's very important for the court to realize that this was a trial with really just one contested issue, and that was the willfulness of these two executives' conduct in not paying the taxes on time, which there was no dispute that that is what happened.
Trust fund taxes.
That's correct.
These are withholding taxes by employer that you're obliged to file and send to the Internal Revenue Service.
That's right, and they were paid quite late, but they were paid, and the allegations were that they were
And they
not.
include not only taxes, but Social Security and Medicare and all that kind of stuff, don't they?
That's
The
correct.
withholdings, they're funds of the employees,
That's correct.
and that's why they're called trust fund. The employer is the trustee for those funds.
Yes.
I remember when I was a prosecutor for a while, but when I was the head prosecutor, they used to come up with programs to emphasize the prosecution of these kinds of cases. 941 cases, I think, that's the form, right?
That is correct.
Yeah, trust funds. Go ahead, I'm sorry.
That's fine, and there is no doubt in this case that the taxes were not paid on time. What the issue was at trial was whether it was willful, and that's because I think like many of these cases, but this was a struggling company, an idea that these executives thought was a great idea and was going to make a lot of, they were going to have a lot of customers and a lot of money, and that didn't end up happening. And when they ended up with a large tax liability, they ultimately got charged criminally. They did get charged criminally considerably after, I think.
They were warned and warned and warned and warned, and they said they were going to do it better and they were going to do it right. And they had hired somebody to help them out, and they never did do it.
That is the government's position. That is not exactly what the defendants testified to. So it is not their position entirely, although they do not dispute that they did not do it on time, and they do not dispute that there was some delay that probably they are responsible for. But their position was, and still is, that they were trying.
They were what?
They were trying to make the company work.
They were trying to do it right.
That's right.
So they were actually then borrowing the trust fund money to use on behalf of the company.
That is essentially what.
Which is, we used to call it, again, going back to my experience, they were stealing from the trust fund and using it for their own use and for the company's use.
That, of course, was the government's position at trial.
Well, and that's a justifiable position.
Sounds like he just admitted it. He said, the judge asked you, did they take it from the trust fund? Sort of like, I guess it's like a lawyer's trust fund. You take something from that trust fund, you might not want to use the word stealing, but you're really misappropriating it.
That's fair. Stealing would
I've
be
made closing arguments and called it stealing. I'll say that. I have made closing arguments to juries and said this is stealing.
as did the government in this case.
And I suspect they did that in this case.
They did. And that's what the jury's decision was whether, well, stealing for one, I think would be putting it in their pocket, which there is not any evidence in this case that that's what was happening.
The company made some money. There's allegations that it made quite a bit of money. And the individuals paid themselves rather substantial monies.
They did. They also
Was
paid.
it any time before they made this final payment, did they ever pay anything?
Yes.
What did
Not
they
a
pay?
lot, but yes.
Well, when did they pay it?
During the times that it was.
Give me the time, because I'm looking at the evidence here, and when I'm tracing down the years, Maybe tell me what year did they pay something?
They paid inadequately or insufficiently in 2014, 2015, and I think maybe 2016 as well. And then they paid in its entirety in 2021 or 2020.
What years are at issue in this case?
The issue I'd like to address is the
What is the basis for the charge here that led to the sentence? What years were you?
14, 15, and 16, or 15, 16, and 17? And the charge,
That's kind of important. I want to know, you said 14, 15, and 16?
yes.
And which of those years did they pay some?
I think they paid a little bit in all of them, but they paid twice, definitely, once in response to a lien, but they did pay twice and I think 3 times in those years.
What did they pay?
Tens of thousands of dollars when they owed hundreds of thousands of dollars.
Okay, go ahead.
I notice my time is up, but if
Well, you only asked for 6 minutes. That's what's up.
I understand, I will be back.
You all are dividing the time.
My time, so continue, sir.
He says you have, I think your partner said you have his time.
Okay. Well, the jury instructions, which we contend were misleading and confusing, the reason we contend they're misleading and confusing is because the judge...
Which instruction are you referring to?
We are referring to the instructions as a whole.
Specifically, we need to know which one
Regarding
you're addressing right now.
Regarding
It can't just be the whole instructions were bad. I mean, which instruction do you allege is
the
bad?
instruction on willfulness and the good faith defense as they apply to the failure to pay trust fund taxes counts. And what the court did on those, prior to trial, the defendants requested instructions which didn't mention the facts at trial at all, and just gave the law. The government requested jury instructions which specifically instructed the jury that they could consider those facts at trial which the government thought benefited them the most, and frankly probably did. And that was...
So when the judge was making, you objected to the instruction and offered an alternate instruction?
There was no specific objection made to the pretrial filing of the government other than the fact that the pretrial submission of the defense was quite different.
Was there a timely objection?
We believe that the pretrial submission is.
Was there a timely objection?
We believe, yes. And that was the fact that they said, these are the instructions we want. The government said, these are the instructions we want. And then when the court said, we're going to use the government's, but we're not going to use some of yours, they did say they didn't agree with it. They also, unfortunately,
Who is they? You said
the
they said,
trial counsel.
okay, but they did not object.
You were not the trial counsel.
I was not the trial counsel,
But
nor was.
there's no objection. That's the question. That's
There was
required.
no, the words "I object to that instruction" did not
Pretty
happen.
simple words, and it kind of what, cases all over the place say you got to say, I object. I mean, it's pretty simple. We try to make that simple for you.
Oh, I understand.
Not just, well, you didn't take mine and they took those, so yeah, I object, sort of thing. That doesn't work.
Well, there are two, well, maybe.
And if you read it literally, that rule is pretty tough on the defendant. And we used to interpret it, that it means that the objections to instructions need to be made after the instructions are given to the jury, but before the jury deliberates, which means, a lot of courts don't do it that way. But the jury got their instructions, they're basically sent out and told to wait, and then the judge gives the lawyers a chance to object to the instructions as given, to see if they need to be fixed or corrected. And then if they do, you bring them back in and give corrected instructions. Then they deliberate. But lots of courts just let them do it before trial or do it during the trial and that kind of stuff. And but that rule is if it's applied strictly, it's pretty tough.
That is true, and in that case, you are correct, there was no contemporaneous objection. We believe that even if the pretrial request is not deemed by this court to be a contemporaneous
But if you
objection.
give if we accord you, you preserved it. If we say we agree you did preserve it, then there's gotta be something wrong with it.
Right.
That's material, and Judge Cogburn is tried multiple cases like this, both as a trial judge and as a trial lawyer. He knows all about instructions, and you have to show us there's some prejudicial error.
Well, what we
That's an uphill battle.
It is. However, what Judge Cogburn clearly did do in this case is commented on, gave specific instructions to consider evidence that was particularly damaging to the defendants on the willfulness question, without giving a concomitant instruction to consider evidence given at trial that was helpful to the defendants on the willfulness question. It is our argument that that combination made the willfulness and good faith instructions, as I said, confusing and misleading, sufficient to require a new trial with either instructions that say nothing about which evidence at trial should be considered on the issue at willfulness, or say both, which evidence at trial can be considered that might be helpful to the government, and evidence at trial that can be considered that might be helpful to the defense. And what was done instead at this trial was there was specific instructions that they may consider evidence that the government asked for because it was particularly helpful to the government. And they did.
You don't claim that was an error of law, right? The statement about willfulness?
No, we do not contend that there was any individual misstatement of law, with one exception that, as the government pointed out, was largely corrected at the end of the jury instructions. Our argument is that the instructions as a whole were confusing and misleading. And now I think I'm about to use up all of Mr. Chartier's time, so I will, unless the court has any other questions, I will reserve the rest for rebuttal.
All right, sir. You're entitled to do that. Mr. Poole?
Good morning. May it please the court. Jason Poole for the United States. So I think there's a simple way for this court to dispose of 4 of the 5 issues here, and that is that defendants have either waived their arguments or failed to meet their burden on plain error. So other than the new trial motion, all of the other 4 issues they have raised in this case were issues that they did not object to timely below and do not even attempt to show plain error in their briefing on. I think the court can find that all 4 of those issues therefore are waived for failing to make an argument on the second, third, and fourth prongs of plain error. And at a minimum, they have failed to meet their burden of showing plain error, which of course it is their burden to carry all 4 of those prongs. In particular, with respect...
You claim that everything they raise is reviewed for plain error?
Other than the new trial motion, Your Honor.
Other than the new trial motion, they made a new trial motion that was denied.
Correct, Your Honor, and that is
So that's preserved?
That's reserved, Your Honor, reviewed for abuse of discretion. The other 4, this court reviews at most for plain error.
Is the basis for the new trial motion preserved?
Yes, Your Honor. I believe the arguments that they've made in their new trial motion and the arguments they make on appeal are the same one. So
Okay.
I do agree that those arguments are before the court properly, although they are reviewed for abuse of discretion.
What about the arguments where they didn't even ask for plain error review in their opening brief?
Yeah, those are the other 4 arguments, and we would argue those are waived because by failing to ask to recognize plain error, by failing to make any argument about any of the prongs of plain error aside from simply assuming that the question was preserved, they have failed to make any argument on the second through fourth prong. So we'd submit that this court can decide all 4 of those as having been waived for failing to assert or argue plain error, and that disposes of all of them for the same reason.
So what's left for you to argue?
Sorry?
What's left for you to argue then?
Not much, Your Honor, other than to recommend that that is the approach this court should take here. Although I will just note in particular, since with respect to the jury instructions argument, counsel asserts that the you should take their initial submission of instructions as being sufficient. As I believe Judge Wynn, as you pointed out, many cases from this court, Cowden in particular, we cite in our briefs, state that you have to object once the instructions are actually given. And here, not only was there no objection, all of these instructions were the ones that they actually agreed to. So there's an invited error here. Literally every issue at the jury instruction conference, the defendants either agreed to the final language or they had an objection which the court upheld and changed the instructions to what they wanted. So these entire jury instructions are ones that, again, they got everything they wanted out of that conference. So at a minimum, on those, you have invited error as well.
Not to quibble, but is agreeing with an instruction, like somebody else proposes an instruction, the court says, this is what I'm going to give, they don't object, that's not really invited error, is it? Isn't invited error, they proposed the instruction themselves, they said, like, please give this language.
So, largely agree with that, Your Honor. I think here, the issues in the instructions they point to are, however, points where they either told the judge affirmatively with respect to the willfulness instruction, Judge, we think this accurately states the law, and there were 2 sentences before that portion that they wanted the court to remove, and the court removed those 2. So that, now if they had just stood silent, I would agree. Then it would just be a question of plain error for a failure to object. But by affirmatively telling the district court, we want you to change this language, but we think the rest of this language is correct and states the law, that should be invited error, because they are then affirmatively agreeing and urging the court, this is what the instruction should look like. So that's the distinction we draw there.
And the error, the contention that you make about plain error, do you think that, or take a position, you, the government, that all those should be resolved on the first prong of the plain error test?
Well, I think our first position is that the court shouldn't need to reach this at all, because the court should find that they have simply waived them by failing to argue plain error. If you were to nonetheless...
But there were at least 2 of them that were preserved. That's the point he's making.
The new trial argument has been preserved. So on the new trial motion, we agree that...
What about the good faith instruction? It seems like there might have been an objection to that.
So same on that one, Your Honor. This is one where there was a discussion where there was an objection originally raised by the defendant saying, we want some additional language about the belief of the defendants does not need to be reasonable, which is part of the tax cheek standard. And the government agreed, we're not going to object to that. We agreed you should insert some language. The language they used was then drawn from the defense's proposed instructions, and the defendants agreed, yes, we would like this language included. And so again, I think that is not objected to, but also, again, an invited error issue as well. So,
and the judge gave a good faith instruction.
He did, Your Honor. And so I think, again, they got everything at the conference they told the judge they wanted.
You don't confess any error, and you don't argue any harmless error.
No, Your Honor.
All right.
No. And so to the question of how we'd like this resolved, again, I think the simplest way for these are waiver. The new trial one is preserved, but in there the judge should not abuse his discretion. And I think so for that one you would resolve on the merits, but it's straightforward that the court had the matters before it, considered the standard, decided it did not meet that standard. Unless there's any further questions, in that case we ask this court to affirm. Thank you, Your Honor.
Thank you very much, sir. Mr. Charnock?
Please the court. Juan Chartier on behalf of Richard Brasser. Your Honor, there are 5 issues on appeal. Issue 5 only applies to Mr. Brasser, and it had to do with the sentencing, but since he was released 2 days ago, we want to remove that and dismiss that as an issue for the court, because it's no longer, it's moot. He was released 2 days ago. So let me address my issue, issue 2, on the IRS voluntary disclosure program. Your Honor is correct that the 2 defendants did not pay on time, but they did pay. And under the IRS voluntary disclosure program. The IRS vets them, they disclose everything, and they come to an agreement where they can pay the trust funds over time, in which they did. There's no dispute to that. But you have to also remember,
So the government got its money.
got his money.
Did they get interest?
They got all their money.
Did they get penalties?
Yes,
But they got it late.
they got it late.
And the individuals got their withholding tax turned
Yes,
over to the government.
Absolutely,
But years late.
correct. But before they were indicted, okay? The government was paid before they were
I thought the
indicted.
government said the trust fund taxes were paid right before the proffer, but there were still some other taxes that weren't paid.
My
Isn't
understanding
that
is.
right? The ones they were holding in trust, but then the ones on their own, the company has to do its own payment? And that
Mine-
wasn't made?
I was in trial counsel, I read the record. My understanding is all the trust funds were paid. This is why they were essentially blindsided when the government indicted them after the fact. Also, you gotta remember that they were charged with two separate and very serious charges.
Well, they were indicted for years that weren't subject to the
No, they were
voluntary
indicted for
disclosure
tax
program.
evasion,
Yeah, for quarters that weren't subject to the voluntary disclosure program.
correct,
Right.
and 2 counts of making a false tax return. They were acquitted on both those counts, on all 3 counts, by a jury. Why? Because the judge gave the proper jury instruction. He didn't, and I'll let Mr. Foster continue. I'll hit this point because the jury instruction that Judge Cogburn did on the failure to pay the trust fund has an instruction on willfulness. Now, under the IRS voluntary disclosure program, you can make certain payments and then pay them later. It's not necessarily willful. Technically, it's willful, but there are exceptions to that. And with that, I reserve my time and allow my counsel to finish on that point.
I think y'all are out of time, aren't you?
He still has 4 minutes, Your Honor.
No, okay. Yeah, Mr. Foster, safe.
Yeah, I don't think I'll take the whole 4 minutes,
That's all right,
but
you
thank
said
you.
4 minutes.
Yeah.
You
I
go
do
right
want,
ahead.
I do want to address briefly the new trial issue. And that is, at post-trial, both defendants made a motion for a Rule 29 motion for acquittal and a Rule 33 motion for a new trial. In the same order, the district court denied them both, and we think made pretty clear that he considered the same arguments as to both the Rule 29 motion and the Rule 33 motion.
Because you made the same arguments, right?
Yes and no. The factual basis for both arguments was similar, although not exactly the same. But the legal analysis is a little bit different, and the defendants made that pretty clear, I believe, in their post-trial motion. And most of the factors, there was one line in the Rule 33 denial about some cooperation with the IRS that the court made. So the court did consider at least a little bit that argument on Rule 33 about the cooperation. But the full payment of taxes did not seem to be considered at all on the Rule 33 motion. Shall I say, sacrifices that particularly Mr. Gentner, but both Mr. Gentner and Mr. Brasser made while it was going on in the mid-2010s in terms of downsizing the company, downsizing their own salary, although we admit they did not zero it out. But they did actually do some of the, and argued this in the Rule 33 motion, and argued that the judge should find that the interest of justice required a new trial. The judge did not appear to consider those arguments at all. If he did, he certainly didn't make that clear in his order. The only language regarding what he considered in that order was the single line that there was some cooperation with the IRS, and that was outweighed by other factors, which he did not identify, and that's why they did not meet the high hurdle to get a Rule 33 relief. Unless the court has any other questions, I think I'm done.
Thank you very much, Mr. Foster.
Thank you.
You've used up all your time now, there's no, is that right? You all- Thank you very much. We'll come down and re-counsel, and before that, we're going to adjourn court for the day. Madam Clerk?
This honorable court stands adjourned, signed, aye. God save the United States and this honorable court.